I don't see the judge.
Yeah, I'm back. Okay, so if we want to go ahead and begin, this is positions 10, 11, and 13. Excuse me, 12 comes after 11, everybody. This is position 10, 11, and 12. This is the state of Georgia versus Marco Thomas. And this is indictment 19 SC 168225, 19 SC 172 400, and 19 SC 168840. Today is September the 29th, 2020. I am in the Fulton County Courthouse. I am not in, I'm not in the courtroom. I'm in chambers, but our proceedings are being being broadcast in a live stream mode on YouTube through the court's channel. The purpose of that is to ensure that our business remains open and accessible to the public. So let me first ask, Ms. McCauley, are you satisfied with this matter being public via YouTube?
Yes, Your Honor, that's fine.
Ms. Hawkins, are you satisfied with this matter being public via YouTube? Okay, you're on mute.
Excuse me, Judge. Recording. The recording.
Oh, yeah. Thanks. Yeah, got it.
Thank you.
Ms. Hawkins, you're I believe you've said you are satisfied with this matter being made public via YouTube.
Yes, Your Honor.
And may I ask Mr. Thomas if you are satisfied with this matter being public for the period of time that we're actually hearing this matter via YouTube?
Yes, ma'am.
Okay, now I'm going to say then that everyone, including Mr. Thomas, is appearing via the Zoom teleconference platform. And we remain in our subject to various emergency orders during our coronavirus crisis. And I'll turn this matter over to Ms. McCauley for any additional questions you might want to ask regarding appearance. And then these matters are on for plea.
All right. Good morning, Mr. Thomas. Can you hear me okay?
Yes, ma'am.
Okay, Mr. Thomas, do you understand that you have the right to be present in the courtroom, but you're waiving that right and appearing via Zoom?
Yes, ma'am.
Okay. And have you discussed appearing via Zoom with your attorney?
Yes, ma'am.
Okay, and you're comfortable moving forward on these cases here today?
Yes, ma'am.
Okay. And do you waive the ability to sign the indictment with your name and permit the court on your behalf to sign the indictments with your name?
Yes, ma'am.
Thank you, Mr. Thomas. Ms. Hawkins, are you satisfied that your client has properly waived his right to appear in the court and is understanding that he is appearing via Zoom?
Yes.
And do you also permit the court to sign your name on the indictment on your behalf?
Yes.
All right. Thank you. Your Honor, the state is satisfied the defendant has properly waived his right to appear in the court and is appearing via Zoom, as well as allowing the court to sign his name and the name of his attorney on their behalf. The state also consents to the court signing the name of its representative on the indictment on the state's behalf.
All right, thank you very much. You can proceed, Ms. McCauley.
All right, thank you very much. All right, Mr. Thomas, can you please raise your right hand?
Yes,
Do you
ma'am.
swear and affirm that the testimony you are to provide to the court is the truth, the whole truth, and nothing but the truth, to help you under penalty of perjury?
Yes, ma'am.
Thank you. Put your hand down. Mr. Thomas, how old are you?
46 years old.
Okay, Mr. Thomas, how far have you gone in school?
To the 12th grade, that I didn't graduate.
Okay. Have you ever tried to take GED classes before?
Yes, ma'am.
Okay. Is that something that you're interested in doing?
Yes.
Okay. All right, Mr. Thomas, can you read, write, and understand the English language?
Some point.
Okay. Do you understand everything that I've said so far to you today?
Yes, ma'am.
Okay. If there's anything that you don't understand, know that you can ask at any time for me or your attorney or the court to slow down, repeat whatever we're saying, and explain whatever we're saying to you, okay?
Yes, ma'am.
And don't be shy about asking, because I say a lot of things that I don't even understand, okay?
Yes, ma'am.
All right. Mr. Thomas, at this time, are you under the influence of any substance, like any medicine, or any drugs that would impact your ability to understand what's going on here today?
No, ma'am.
Is there any medication you normally take that you've not had today?
Yes.
Okay, what medication is that?
My Prozac, I gotta wait till they refill my prescription.
Okay, when you take Prozac, does it help you function and understand what's going on?
Yeah, ma'am. Cause you know I have cloudiness be in my, in my head sometimes.
Okay, right now, can you understand, do you feel like you're understanding everything that's going on without taking that Prozac today?
Yeah, I'm all right for a minute, man.
Okay, you're gonna be all right. If at any time you don't feel all right or you feel like you're not understanding, please say something, okay?
Yeah, ma'am.
Okay. And have you had enough time to discuss all of these cases with your attorney, Ms. Hawkins?
Yes, ma'am.
And are you satisfied with her representation?
Yes, ma'am.
Okay, and Mr. Thomas, you understand that you're entering into a negotiated plea. What that means is that the state, so me and your attorney on your behalf, have come to an agreement as to how we think your 3 cases that are before the court, how they should be resolved. And I'm recommending, and your attorney is recommending, that you receive a sentence of 5 years probation, and you're going to get credit for a year of incarceration when you start mental health court. Okay. So that mental health court is going to be your probation. If you start mental health court and you're successful in completing it, that'll basically be the terms that you'll have to comply with in your cases. Do you understand that?
Yes, ma'am.
Okay. Do you have any questions about that?
Yeah, the program, what it was supposed to be from 18 to 24 months.
Yeah, so it's an 18 to 24 month program, and how much time you're in the program largely depends on your participation and how well you do. There's going to be a staff of people that are going to work with you on a variety of different issues. Some may be working with you about your behavioral health and your mental health. Others may be working with you on substance abuse issues. There may also be some help for job training and job placement. So as long as you comply, the faster you'll get through it. Okay. If you
Yes,
have a
ma'am.
bump in the road or something, doesn't go the way that you thought it would, then it might take longer to get through the program. Okay. But it's a program that's set up to help you. So the more you put into it, the more you'll get out of it. Does that make sense?
Yes, ma'am.
Okay. I'm going to go through the cases that you're pleading to today. So the first one is the case number is 19 SC 168225, and the charges are as follows. So it's possession of MDMA, possession of marijuana less than 1 ounce, possession of
Yeah.
cocaine, obstruction of a law enforcement officer. That's one case, okay? Second case is the case number is 19 SC 172400. Those charges are as follows: possession of cocaine and obstruction of a law enforcement officer. Then there's a third case, and that's 19 SC 168840. And the charges in that case are possession of heroin, possession of marijuana less than 1 ounce, possession and use of drug-related objects, and obscured or missing license plate. So those are the 3 cases that you have, Mr. Thomas, and those are all the charges that you are charged with. Do you understand all of those charges?
Yes, ma'am.
Okay. And do you understand what the negotiated recommendation is?
Yes, ma'am.
Okay. Do you need any more time to talk to your attorney about these cases?
No, ma'am.
Okay. Again, if you have any questions, you speak up, okay?
Yes.
All right. You understand that by pleading guilty today, you're going to give up a number of rights. I'm going to read those rights to you, and then I'll ask you at the very end if you understand after I read through that list, okay? By pleading guilty,
Yes, ma'am.
you're giving up the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to the presumption of innocence, the right to have the charges against you proved beyond a reasonable doubt. You have the right to testify in your own behalf, should you so choose. You have the right to confront and cross-examine the state's witnesses, as well as any other evidence that would be presented against you. You have the right to compel the production of evidence. So you have the right to subpoena your own witnesses, and you have the right to present your own evidence in your own defense. You have the right to be represented by an attorney at that trial. And if you cannot afford to hire your own attorney, you would have one appointed to you at no cost to you. And if you were to be convicted, you would have the right to file an appeal to challenge that conviction. Do you understand those rights, Mr. Thomas?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up those rights?
Yes, ma'am.
Has anyone threatened, forced, or otherwise promised you anything to get you to enter into this guilty plea?
No, ma'am.
Do you understand if you have any open cases, suspended sentences, or are currently serving on any term of probation or parole in any jurisdiction, including federal court, a conviction in this case may have a negative impact on those sentences?
Oh, Lord.
You're not currently on probation in any cases, are you, Mr. Thomas?
No, ma'am. But I have a case coming up in DeKalb County.
Okay, so this conviction might impact your case in DeKalb County, but it likely won't. Okay, but make sure that when you talk to your attorney in DeKalb, that you let them know that you had these cases in Fulton and that you resolved all of them. Okay.
Yes.
Okay. Do you understand that this conviction can be used against you in the future as use of evidence in a future case, to impeach your testimony, or to enhance a future criminal sentence?
What do you mean by that?
Okay, so what I mean by that is, so if you say you're arrested again and charged with possession of cocaine, okay, in the future, say 5 years from now, the state can try to use your prior cases as what's called a similar transaction, which is the state would have to file a motion to say, this defendant had committed a crime in a similar way previously, and we want to try to use it against him in this new case. Okay, so that's one way these cases can be used against you. The second way is for impeachment of your testimony. In the state of Georgia, if you are convicted of a felony, which any felony is considered a crime of moral turpitude, but if you're convicted of a felony, if you were to testify in another case, even as a witness, say you witness a crime, they can say, in court, Mr. Thomas, you've been convicted of a felony, correct? And that's called impeachment when they do that.
Oh.
Okay.
Yes,
And then the last one is for sentencing. So this won't apply for your DeKalb case because the conviction has to exist at the time when the new crime is committed. Okay.
Oh. Okay.
But say you were to be convicted of a crime 10 years from now, you will have these 3 convictions, and I will put it on the record that these cases are being combined for the purpose of recidivist notice. So they can use this conviction against you under what Georgia calls its 3 strikes law. So if you get 3 or more felonies, the state can ask for a certain amount of confinement or mandatory sentencing for certain crimes if you have 3 or more prior felonies. Okay. Okay. And what I just said was I'm combining these cases today for the purposes of recidivist. So that means that these 3 cases can only be used as one conviction. Okay. So they're going to count as 1 on your criminal history. They're going to appear as 3, but for the purposes of that 3 strikes law, they're only going to count as 1. Do you understand that?
Yes, ma'am.
Okay. Do you need any more explanation on those issues?
No, ma'am.
Okay. And you understand everything I just explained to you?
Yes.
Okay. All right, Mr. Thomas, are you a United States citizen?
Yes, ma'am.
Okay. Do you, if you were not a United States citizen, these convictions would have a negative impact on your immigration or visa status. And you understand that?
Yeah, ma'am.
Okay. And the last thing I'm going to explain is what's called habeas corpus rights. You have 4 years from today on any felony charges and 12 months from today on any misdemeanor charges to file a document called a habeas corpus petition. What a habeas corpus petition is, it is a document, it's a legal document that you can file, and you can do it with the assistance of an attorney or
Yeah.
on your own. You can do it on your own as well. That says that this plea was not voluntary because you were somehow coerced or forced to do that. Okay.
Yes.
And you have 4 years from today to file that document and 12 months from today to file it. So you understand that?
Yes, ma'am.
Okay. So as to the charges, and I'll go through them once again. So on 19 SC 168225, possession of MDMA, possession of marijuana less than 1 ounce, possession of cocaine, and obstruction of a law enforcement officer. And on 19 SC 172400, possession of cocaine, obstruction of a law enforcement officer. And the last indictment, 19 SC 168840, possession of heroin, possession of marijuana less than 1 ounce, possession and use of drug-related objects, and obscured or missing license plate. What is your plea today, Mr. Thomas? Guilty or not guilty?
Guilty.
And do you enter this plea knowingly, willingly, freely, intelligently, with the full facts and knowledge of the cases before you?
Yes, ma'am.
All right, thank you very much, Mr. Thomas. Your Honor, the state and defense have stipulated that a factual basis exists for all 3 cases. Is that correct, Ms. Hawkins?
Yes, that's correct.
Thank you very much. And we would just request that the court accept the negotiated plea of 5 years to serve 1 year, commuted time served upon entry into mental health court
Yes,
or
ma'am.
behavioral health court, with the balance to be probated. And so that's a track 3 drug court or mental health court.
Will the balance be suspended after the,
It'll
Yeah.
be through, it'll be 5 to serve 1 upon entry into behavioral health court, and we will suspend the balance after you complete mental health court.
okay.
Okay.
Yeah, cause she had explained it to me. She said after 18 is 24 months that they'll suspend the balance on the rest of the probation and stuff.
We will do that, Mr. Thomas.
Yes, ma'am.
Okay. Thank you for reminding me.
Yes, ma'am. Thank you.
All right, anything further?
Nothing from the state, Your Honor.
Okay, and Ms. Hawkins, you do stipulate to the sufficiency of the facts underlying the charges.
Yes, Your Honor, we stipulate to the facts. Mr. Thomas, we initially wanted to get him into drug court. However, because he has a mental health diagnosis, everyone decided that behavioral health court was a better suit for him. It's obvious that he was, in a sense, self-medicating. So we're just hoping that Mr. Thomas can go to behavioral health court, get the help that he needs so that he can be a productive member of society.
Okay, Ms. Hawkins, do you know anything about Mr. Thomas's criminal background?
I don't have those notes with me, Your Honor. I think if he has a history, it's all drug related. Is that correct, Mr. Thomas?
Yes, ma'am.
That's what I was going to, whether there were any
Has anything
crimes of violence.
violent or anything, Mr. Yeah, no, I don't think so.
No, ma'am.
No.
Okay, well, is that all from you, Ms. Hawkins?
Yes, Judge.
Okay, Mr. Thomas, I have some questions for you. This is Judge Barwick, and I know that you've been present on the computer
Yes,
for
ma'am.
quite some time, and I want to thank you for your patience and
Yes, ma'am.
acknowledge your presence through a lengthy calendar. And I've got some questions for you. And my first question is, did you understand the questions asked of you here today by the Assistant District Attorney, who was the lady asking you the questions?
Yes, ma'am.
Okay, and it's really important to the court that I make certain that you're doing this voluntarily and that you know what you're doing. Do you feel like you know and understand what you're doing?
Yes, ma'am.
Okay, and do you understand the rights you're giving up as they were explained to you by entering your pleas of guilty today?
Yes, ma'am.
And are you willing to give up those rights and go ahead and enter your pleas of guilty?
Yes, ma'am.
Has anybody promised you or threatened you in any way to get you to do that?
No, ma'am.
Are you satisfied with the services of your attorney, Ms. Hawkins?
Yes, ma'am.
And do you believe you've had adequate time to discuss these cases with Ms. Hawkins?
Yes, it's been, well, almost 4 months ago when we discussed it.
Okay. And do
So,
you feel you need any additional time to talk to her?
No, ma'am. I talked to her a couple of days before the case came up. She had called and talked to me.
Ms. Hawkins, do you feel like you need any additional time to talk to Mr. Thomas?
No, Your Honor.
And do you feel like he knows and understands what he's doing today?
Yes, Your Honor.
Okay, well, I find that Mr. Thomas is entering his plea knowingly, freely, willingly, and voluntarily. Mr. Thomas, I think it's clear you paid very close attention to the questions, and you had some questions on your own, and those were good questions, and they were answered for you. And so I do believe that again, you're entering your plea knowingly, willingly, freely, and voluntarily. The lawyers have agreed and the court accepts the stipulation that there's an adequate, sufficient factual basis for the charges presented to the court. And I do accept your pleas of guilty today. And
Yes, ma'am.
therefore, in the indictment ending in 225, and this is a global resolution to 3 indictments. So y'all are gonna sort of have to, does the 5 years, Ms. McCauley, in each of these indictments, does count 1 support the 5 years?
Yes, Your Honor. I think it's consistent across all of them that 5 years is actually the minimum that we could do for all of these.
Okay, so in the indictment ending in 225, on count 1, the court hereby sentences you to 5 years to serve 1 year. That 1 year to be satisfied by your entry into drug court, and I understand that he's been accepted into, mental health court. I understand that
ma'am.
he's accepted into mental health court, correct?
Yes, ma'am.
That is correct, Your Honor.
Okay, now the balance will be on probation, but that probation will be suspended upon his completion of the mental health court. So I just want to make sure that everybody, including me, understands that he is not in custody now. He will go into the mental health court, and that will satisfy his 1 year to serve, correct?
Yes.
Okay, all right. The balance would be on probation, and that probation then would be suspended upon his completion of the mental health court. Okay, now on counts 2, 3, and 4, I don't know whether those are all would support the 5 years, but those would be, can anybody help me there on 2, 3, and 4 in 225?
So count 2, possession of marijuana less than 1 ounce would be 12 months.
Okay,
Possession of cocaine should be 5 years.
okay,
Count 4, obstruction of a law enforcement officer, that's a misdemeanor, so that's 12 months.
okay. Okay, I think I can do the rest. Okay, so on count 3 would be the same sentence as count 1 to run concurrently with the sentence in count 1, and counts 2 and 4 would be 12 months to run concurrently with the sentence in counts 1 and 3. And the indictment ending in 400, count 1 would be the same sentence, 5 years to serve 1. That 1 to be satisfied by the entry into the drug. I gotta just cross my notes out here. To be satisfied by the entry into the mental health court program, which I understand is track 3, with the balance probated and the probation to be suspended upon his completion of mental health court. 2 is 12 months to run concurrently. That the sentence in the indictment ending in 400 to run concurrently with the sentence in the indictment ending in 225. The indictment ending in 840 on count 1, same sentence. And counts 2, 3, and 4 would be 12 months each to run concurrently with the sentence in count 1. And 8, the indictment ending in 40, that those sentences will be concurrent with 2.5 and 400. Is there anything else?
Nothing from the state.
Anything else from the defense?
Nothing from the defense, Your Honor.
Okay, Mr. Thomas, again, appreciate your being with us today. I want to wish you luck, and I want to really encourage you with this mental health court.
Yes,
That's
ma'am.
run by an excellent judge. I think you're going to get a lot out of it. As Ms. McCauley kind of said to you, you're going to get out of it what you put into it. And I really hope that you will take advantage of it.
Yes, ma'am.
Because this is one time that the government is actually tapping on your shoulder and saying, we're here to help you, and we really mean it. We are
Yeah.
here to help you. So best of luck to you, sir. And if there's nothing further, I believe we have now actually concluded our proceedings.
But we do need to, he's gonna have to talk to probation. So Janie, you have his telephone number so she could call him?
Yes.
Okay, I have her email. I just, I asked her to come back on, but it was after a few minutes. So I will give, if you send me his phone number, Jenny, you can text it to me. And
Okay, I'll do that.
Send it to her so she can get in touch with him.
So
Okay.
Mr. Thomas, a
Yeah,
lady
ma'am.
who was on the computer earlier is with the probation office. She's going to call you and give you all of your instructions, and you need to take that call. Okay.
Yes, ma'am.
Okay. All
And
right.
Mr. Thomas, if you have any questions, you can always call and text me.
All right. Thank you.
You're welcome.
All right. Thanks,
Thank you,
everybody.
Jen.
And now we will conclude our proceedings for the day. I hope the walking wounded all go take care of themselves. And thank y'all very much.
Yes.
Thanks, Judge.
Thanks, Judge.
Bye-bye.
Thank you.